Hello everyone. In this segment, we will talk about professional ethics for a lawyer. Fundamental prerequisite of any profession is good ethics. Ethics denotes to human behavior to make decisions between what is correct and what is wrong. Professional ethics are those set code of moral principles that governs a person's conduct in a professional workplace or work life. In the legal profession, a lawyer must obey to professional codes for fair dealing with the client and uphold a self-possession. The Indian government has established a statutory body known as the Bar Council of India under the Advocates Act 1961. Advocates Act 1961. It was introduced to implement the recommendations of the All India Bar Committee and taking into account the Law Commission's recommendations relating to the legal profession. The Parliament has established the Bar Council of India under Section 4 of the Advocate Act 1961. As per Section 71B of the Council has to lay down standard of professional conduct and ethic for advocates. And Section 449 Clause 1 Subclause C allows the Bar Council of India to make rules as to suggest the standard of professional conduct to be observed by advocates. Bar Council of India rules. Bar Council of India has framed the rules under Part 4 of Chapter 2 dealing with the standard of professional conduct of lawyers. This chapter states 39 rules or duties of the lawyer against court, client, opponent, etc. Lawyer's duty towards court. Duties of advocates to courts are: first, to maintain a respectful attitude and dignity towards court. Second, not to impact on the decision of a court by any unlawful or inappropriate means. Third, use his best effort to avoid his client from doing unfair practices. Fourth, to appear in the court in the prescribed dress and a presentable manner. Fifth, to wear bands or gown in courts only for ceremonial occasions and not in public places. Fifth, not to plead in any matter in which he is himself interested. Sixth, if he is a member of any executive committee of organization or corporation, then he cannot appear in or before any court or any other authority or represent the case of that organization. Lawyer's duty towards client. Once accepted, then cannot withdraw from actions or engagements without appropriate cause. Second, should not accept and appear in case in which he has reason to believe that he will be a witness. Third, to make full disclosure against his connection with the parties or interests before the commencement of the engagement or during the process. Support the interest of his client by all moral means. Not to overpower any material or evidence which shall prove the innocence of the accused. Not to reveal the communication or talk made by his client to him. Not to charge for his services depending on the success of the matter taken. Do not adjust fee payable to him by his client against his liability to the client. Lawyer's duty towards the opponent. An advocate has some responsibilities to opponent, but lawyer's duty towards the opponent. An advocate has some responsibilities to opponent also, such as he cannot communicate or negotiate with any party represented by an advocate except through that advocate upon the subject matter of conflict, to carry out all valid promises made to the opposite party. Punishment for professional misconduct. As per Section 35 of the Advocate Act 1961, if a person is found guilty of professional misconduct, then the case will be referred to a disciplinary committee. Then they fix a date of hearing and issue a notice to the advocate. And the disciplinary committee of the State Bar Council will hear both the parties. The court may dismiss the complaint, warning to advocate, suspend the advocate from practice for certain periods of time, remove the new advocate from the state role of advocates. That's it.